Okay.
All right, this is case number 2513687 FC, People versus Jeremiah Crumb. We're here for a pretrial conference. The court has been advised the defendant wishes to enter no contest plea. Is that correct, Mr. Prysock?
Yes, Your Honor. We had previously filed a no contest plea. It didn't satisfy the elements of the offense, so we filed an amended plea after I met with Mr. Walburn of the prosecuting attorney's office and met with my client. And so we filed that amended no contest plea.
All right, Mr. Crumb, raise your right hand. You solemnly swear oath or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Ms. Robinson, would you put the agreement on the record, please?
Yes, Your Honor. The agreement with the defendant will plead as charged, minimum to be determined by the court. I believe the court committed to 25 years, maximum at 50 years, and we will not seek a consecutive sentence. And it is my understanding that the defendant is intending to plead no contest as he is currently charged and avail himself of that offer. So we will not seek consecutive sentencing.
All right, and Mr. Prysock, is that your understanding of the offer in this case?
It is, Judge. I think we had discussed the last time we were in court, and I think the court had indicated that the court would give him the 25-year mandatory minimum of the 50-year maximum. I think the court has some discretion to sentence within that period, but I believe the court did state that you would give him the 25-year minimum.
Yes.
Yeah, so with that in mind, Judge, yes, he would enter as no contest.
All right, so, Mr. Crumb, the charges that you are entering a no contest plea to read as follows: that on or about September 15, 2025, you were in Bridgeton Township, William County, State of Michigan. You had 2 counts of criminal sexual conduct in the first degree. Victim less than 13, defendant 17 years of age or older. That you, being 17 years of age or older, did engage in sexual penetration to it, penis to mouth, with a child under 13 years of age. This is a Tier 3 offense under the Sex Offender Registration Act. You should also take notice that pursuant to MCL 333-5129, upon bind over circuit court or recorder's court, district court order shall order the defendant to be tested for venereal disease, hepatitis B, and for the presence of HIV or the antibody to HIV, if there has been a determination that the violation included sexual penetration or exposure to body fluid. If the judge didn't do that, then now it is mandatory. You understand that?
Yes.
This is a felony which would be life or any term of years with a mandatory minimum of 25 years in prison and lifetime electronic monitoring, mandatory AIDS STD testing. And the court may impose a consecutive sentence under MCL 750-520B3. Do you understand count 1 and count 2 and the maximum penalties?
Yes.
You're also pleading as a habitual offender 4, which indicates that people believe that you were convicted of operating or maintaining a controlled substance laboratory November 30th, 2015 in the 14th Circuit Court for Muskegon County. Do you have that prior conviction, sir?
Yes.
January 27th, 2017, possession of methamphetamine in the 14th Circuit Court. Do you have that conviction as well?
Yes.
And September 15th, 2017, operating while intoxicated offense.
Yes.
And that was again in the 14th Circuit Court for Muskegon County. Do you have that conviction as well?
Yes.
Do you have any prior criminal sexual conduct convictions?
No.
Any prior assault convictions?
No.
What do you have for misdemeanor convictions?
I think possession of marijuana.
A couple drunk drivings, probably.
Yeah.
Anything else other than that?
That's it.
You understand that the habitual offender force could increase your advisory guidelines. Now, the agreement in this case was that you were to plead guilty as charged. Do you understand that?
Yes.
And that with your guilty as charged, the people would not be seeking a consecutive sentence. Do you understand that?
Yes.
Now, the court's indicated that if, or I would say it this way, unless the pre-sentence investigation report reveals something I'm not aware of, I've committed to a minimum sentence not to exceed 25 years with the maximum not to exceed 50 years. Do you understand that? Now, if I start looking at your pre-sentence report and there's more to your criminal history or other things that would raise issues with me, then I may reject this plea. Do you understand that?
Yes.
But if I reject the plea, then you're not bound by your no contest plea. Do you understand that?
Yes.
So unless the court does not go along with this plea, you understand that your sentence would be 25 years on the minimum to a maximum of 50 years with the Michigan Department of Corrections. Understand that?
Yes.
And you'd be subject to lifetime electronic monitoring. Do you understand that? Is that your complete understanding of the agreement as it stands today?
Yes.
We've had sufficient time to consult with Mr. Prysock about your charges and this plea agreement.
Yes.
And subject to the plea agreement, how do you wish to plead?
No contest.
Reason for the no contest plea, Mr. Prysock?
Judge, I believe that there would be, there is potential civil liability that could arise from this case.
The court does agree that that is an appropriate reason for offering a no contest plea in this case. Now, Mr. Crumb, do you understand with a no contest plea, you're not admitting these charges, but you're no longer denying? Understand that? The court's been provided a couple of different excerpts from the police report. Number one, your statement. And number two, the statement of the victim in this case. And if after reviewing those police reports, I find that the elements of these two offenses are in that report, I would find you guilty. Do you understand that?
Yes.
You'd be convicted of these two offenses. Do you understand that? It'd be on your record. Do you understand that?
Yes.
And you'd be subject to sentencing according to this plea agreement. Do you understand that?
Yes.
You also understand that if I accept your no contest plea, you're giving up the right to have a trial of any kind. Furthermore, do you understand that you're giving up the rights that you would have at that trial? We've provided those rights to you in writing on the sheet that you signed today. Did you read that document?
Yes.
Did you understand those rights?
Yes.
Did you go over those with Mr. Prysock?
Yes.
All right. So just to be sure, do you understand that you're giving up the following rights by entering a no contest plea? To be tried by a jury,
Yes.
Be presumed innocent until proved guilty.
Yes.
To have the prosecutor prove beyond a reasonable doubt that you are guilty.
Yes.
To have the witnesses against you to appear at the trial.
Yes.
To question the witnesses that the people would call against you.
Yes.
To have the court order any witnesses that you would have for the defense to appear at the trial.
Yes.
Giving up the right to remain silent during the trial. You're giving up the right to not have that silence used against you. Giving up the right to testify at trial if you want to testify.
Yes.
Do you understand that you're giving up, or that you may be giving up the right to appeal any appealable issues you may otherwise have if you were convicted at trial? Do you understand that any appeal of your conviction and sentence pursuant to this plea will be by application for leave to appeal, and it's not an appeal by right? Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than we placed on the record?
No.
Are you entering this plea of your own free will?
Yes.
I understand that if your no contest plea is accepted, you're giving up the right to later claim that this plea was not your choice. And as I indicated to you before, you understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea. You now want to give up your right to have a trial of any kind, and all the rights that you have at that trial. And do you affirm, or do you still want to plead no contest?
Yes.
All right. And Ms. Robinson, no objection if the court reviews the information that was submitted.
I think that's appropriate, Your Honor.
All right, the court does find that the elements of these two offenses are contained in the report. The court previously indicated that there was a potential issue if merely licking a penis would be considered as penetration. That statement as to the licking came from the defendant's summary of an interview. The court now has had an opportunity to review the interview with the victim in this case, where she clearly indicates that that he put his penis in her mouth. So that would be sexual penetration. It's also clear from the report that the victim in this case was less than 13 years of age, and also that the defendant is older than 18 years of age. So the court does find that the elements of the offenses are contained in the report.
Judge, if I may, just so we don't have any issues later, I think it also indicates that it happened twice, because we have 2 counts.
Yes, yeah. I said these offenses.
Okay, all right.
So there were
Thank you.
multiple instances that were related, and I do find that there's factual support for both offenses. So are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
There are none, Judge.
Is he competent to enter this plea?
As far as the people are aware, Your Honor.
He is, Judge.
Does the court comply with MCR 6.302?
Court has, Your Honor.
Court has.
All right, the court does find the plea to be knowing, understanding, voluntary, and accurate. I'm going to refer him to the probation department for the preparation of the pre-sentence investigation report. I'm going to set sentencing for March 17th at 9:10.
Meet with Mr. Zurich, some stuff like I said.